Welcome to our webinar. We're going to get started. Sorry for it's a couple minutes delayed. This is something we hadn't really planned because this was a bit of a surprise in terms of the decision that recently came down from the Supreme Court reversing Roe v. Wade. But it doesn't directly impact our planning and mostly how we advise clients, but it does impact a lot of our clients. And I think it's such an important change in the law, and it affects a lot of families and a lot of individuals in different ways. And it's a very personal issue, and we deal with clients in their personal lives and their family lives. And so I thought that it would be a good idea to just have do a discussion on this and to talk about what this decision means and if there's anything that you can do to protect your family. So we'll get started. And if you have any particular questions, you can just go ahead and put them in the chat, and we'll try to get to them. But I tried to cover the biggest issues and the most salient issues that are kind of present at this time. Okay, so the name of the Supreme Court case is Dobbs versus Jackson Women's Health Center. And this involved a Mississippi abortion ban on abortions after 15 weeks. And so the court basically decided that the Mississippi it upheld the law, and it went further than just upholding the law and completely reversed Roe v. Wade, eliminating a constitutional right to abortion. I think it's important to note that this decision was 6-3. So there are 9 justices on the court. Close decisions are 5-4. 6-3 is you can see how the court is really very one-sided in terms of the conservative view on issues like abortion and guns, and there are just so many issues that are coming up. So we're not even at it. It's kind of surprising this wasn't even such a huge step for the court to take, but it wasn't even a really close decision. So Justice Alito wrote the opinion upholding the law and holding that Roe v. Wade should be reversed. The opinion was joined by Justice Gorsuch, Kavanaugh, and Amy Coney Barrett. Thomas and Kavanaugh concurred, and Roberts joined in the judgment. Joining in the judgment means you don't agree with the opinion, but you agree with the conclusion. So Roberts agreed that the abortion ban should be upheld, this particular law should be upheld, but he found that it wasn't actually necessary to reverse Roe v. Wade. This was sort of the court wading into territory that it wasn't necessary to do to address the issue before it. And that's kind of an important thing because generally the court doesn't address issues that are beyond the particular issue before it. So Roberts said we could uphold this law saying that there is no right to abortion before 15 weeks without actually eliminating the right to abortion entirely. And then in that case, you kind of just wait until another decision came or another case came before it to that was a complete ban, and then decide that issue. And he didn't say that he wouldn't agree to reverse Roe v. Wade. So we can kind of only imagine, guess what his thoughts would be on that. The dissenters, of course, we have Justice Kagan, Sotomayor, and Breyer. This is just a map of what we are seeing after this decision. So previously, you definitely had a lot of variation in terms of abortion rights in different states. Some were more lenient than others. And in the last couple decades, there have definitely been more and more restrictions, ultrasound mandates, waiting periods, all kinds of things that would limit the right to get the ability to get an abortion. But now you're just seeing blanket bans. So some of these states do not, the laws do not even uh, they do not even have any exception for rape or for incest. It's complete ban. All of the states currently do have a right to protect the life of the mother. So if the life of the mother is in danger, then an abortion would be allowed. But we'll see that that's not quite as clear cut as it may they may think it is or they're purporting it is. So, and in New York, I think most of the people here are in New York, still, the right to abortion. I don't foresee it going away anytime in the near future. In this state, it's not reliant on the federal constitutional right. So there are many states where that right is still protected, but as you can see, there are vast tracts of the swaths of the country where we're in a completely different situation. So the immediate aftermath, so in addition to the limit on the right to get an elective abortion, there are complications that I think are not really given enough attention in this debate, and that is that how intertwined the right to abortion is in maternal health care and pregnancy, the treatment of complications during pregnancy. Um, there where there are kind of gray lines, doctors will may be really reluctant to perform procedures or life-saving measures and procedures or medication because they are afraid of going to jail or being or losing their medical license. So even where the mother's life is at risk, this is we're seeing already delays, and because the doctors have to consult with their lawyers, it could take many hours, possibly days. They may end up waiting until, so if there's a sign that there is a problem that is a potential risk, then they may have to wait until, well, the patient is kind of at death's door and they have to try to, get basically try to completely like save the life when it could have been done at a much easier, a much better stage if it was done earlier. So this is something that even if you're not looking to get an abortion, I think if you are pregnant or are considering getting pregnant, that this is something that I think is really important to be aware of. Other um, issues that are come up are IVF, are frozen embryos and unborn child. We haven't seen right now that being legislated, but you can pretty easily see how that may be a result of this law and that states um, may go ahead and try to, I don't know, quote unquote, require that those embryos be implanted and born. That would be a pretty dystopian uh, result, but we kind of just don't know what we're in for right now. The impact of healthcare in New York. So, like I said, the impact on abortion services in New York should not be affected. However, it's affected in the sense that there will be higher demand for abortion services in those states where it is legal. So states like New York could become destination states for women seeking to have an abortion. So that could kind of put pressure on the services here and make it harder for even New York residents to get those services just because the demand is going to be increased. And the same with treatment for high-risk pregnancies. So if you have a high-risk pregnancy, those doctors in other states may completely stop treating high-risk pregnancies because they often require an abortion care. And so you may just see a pullback in many of these states with restrictive laws of that kind of care because of kind of like a chilling effect on the profession. And so a lot of those women may end up coming to New York and increasing the demand for services here in the state. There's a question in the Q&A saying, we have a PA resident here about to start IVF retrieval and wondering if I am opening myself up to legal problems later if I make more embryos than I intend to use and laws in PA change once I have these. Unfortunately, I can't dismiss that concern. It is a possibility. I don't think it's likely, but it is a possibility, and this is something that an issue that has come up. I don't think I would personally make that decision based on the potential that there could be an issue later on. I think that what may happen is that some of these clinics will end up storing the embryos in other states. So they may have storage in New York State if Pennsylvania looks to start regulating that area. So I think there will be options, but it is something where to just be on the lookout for. But I would consider I would consider that that this just kind of be aware of it, but I don't think I would make that decision and not go ahead with it because of that concern. A question about sort of this dystopian scenario where the state would mandate that embryos be implanted and born. Would the jurisdiction be the state where the embryo is created or where it is stored? So these are all really good questions, but I think that right now we don't have that situation, and I think that if this would come into effect where there were these kind of really draconian laws, I think you would probably see changes in the states where, one, moving the embryos out of that state, and then those states where they were stored, I think would be really, really reluctant to hand them over as a part of any kind of lawsuit from the other state. So I think that there is a possibility that we can see, and we've had more division and polarization in this country. I think this is really going to increase it, because I just feel like if a state like New York, if there was embryos stored here, I feel like there would be a really big fight to give those up to a state that was mandating that kind of action. And this is also something that can be done, unfortunately, it's potentially can be done at the federal level as well. So that could be good in the sense that, well, Congress can require this can't be done. And it could also be bad in the sense that Congress may be able to mandate that it could be done. So it not being in the hands of the court just really puts it in the hands of either the states or Congress. And we're not really sure at this point whether we're looking at that in terms of this is just going to be relegated to the states, and the court is going to say only the states can regulate this, or if they will say, well, Congress can regulate it as well, we just can't as the court. We haven't seen that case yet because we haven't been in this situation. So, but I think that's something that's going to come up very, in pretty short order. Okay, so questions raised. Abortion by medication. Currently, doctors can prescribe across state lines, I believe. Will there be, will the doctors in New York be subjecting themselves to prosecution in another state if they're prescribing to another, to somebody in that state? That's a question. Will pharmacists be able to refuse to prescribe that medication? And currently, that's kind of what we're seeing. But that, I think we're looking at a very different scenario or situation and landscape now than we were pre Roe v. Wade, because abortion can be obtained through medication, which we just didn't have that before Roe v. Wade. So it's going to be a lot harder for states to regulate this. But and then on the other side, it could be a lot more dangerous because they think if women cannot get that medication legally, they may be trying to get it illegally, which can create, if something is not regulated, then that may cause all kinds of problems. The right to travel. So this is going to be a big issue. Will women be able to travel to other states to get an abortion if it is banned in their state? And it's not clear where we are on that. In Justice Kavanaugh's concurrence, he said that states wouldn't be able to prohibit travel to obtain an abortion. What that actually means, we don't really know. Does that mean, well, they couldn't like physically, ban you and detain you? Or does that go further and say, well, they couldn't fine you, they couldn't criminalize you after the fact? We don't really know. Also, Justice Roberts, we don't know what his take on this is. So even if Kavanaugh says, well, we have the right to travel, that may not be enough because it is a 6-3 decision. We may have Justice Roberts, we don't know where he would fall on that. Who will be punished? So currently in all states, only the providers of abortion are punished. But I think that as it becomes more evident to states that it's difficult to restrict abortion or eliminate abortion through, it's kind of a fantasy anyway to eliminate abortion, because we know that it takes place even under the strictest bans that's happened previously. But I think that we'll see potentially more of a focus on targeting the women who are seeking abortion and who are obtaining abortion because of this travel issue and because of the medication issue. It's going to be a lot harder to prosecute the prescribers if they're in different states. So that's something that we kind of need to be on the lookout for. There are some attempts to mitigate the damage, but they are limited because the Democrats currently only have a very slim margin in the Senate. The Biden administration has issued guidance saying that a refusal to fulfill a prescription for medication abortion may violate anti-discrimination laws. So pharmacies could put themselves in in a situation where they may be found in violation of anti-discrimination laws. On the other side, in states, they may be criminally liable. So they may find themselves in a really difficult situation. And I'm not sure how all of that will play out. But the administration has attempted to at least encourage or kind of warn pharmacies and warn states that this is not something that they cannot really get away with just refusing to make this type of medication unavailable. Other attempts to mitigate this, to mitigate the results of the decision, the administration has also emphasized that hospitals must provide medical care to stabilize a patient presenting with an emergency medical condition. So if the patient's life is at risk, then they must perform any kind of medical treatment to stabilize the patient. Of course, stabilizing the patient isn't the same as completely treating their condition. So that still leaves a lot of room for problems in those conditions, in those situations. The right to travel, the House of Representatives has passed a bill protecting the right to travel for purposes of obtaining abortion. It is not likely to pass the Senate, so I don't think that is going to be going anywhere, basically because of the filibuster. So we talked about the direct impact of this decision on reproductive health care, but could also be ripple effects of this decision. So what we've seen in in the opinion by Justice Alito is a complete shift in the framework of constitutional analysis of what rights are protected under the Constitution. And the analysis that they use is that if a right is not explicitly mentioned in the Constitution, it is only protected if it's deeply rooted in our nation's history and traditions. That really has us looking back to either the early days of the 18th century, or the early days of our Constitution, in the late 1700s, or when the 14th Amendment was passed, which was in, I'm going to say 1865, but somewhere around there. So in either event, there are whole swaths of the country, in different populations, who did not have recognized rights at that time. So women, minorities, any LGBTQ population. So any of those populations and protections for those populations are, I think, at risk, if they, and the text of the 14th Amendment protects on the basis of saying equal protection, but it doesn't say what populations, like the protection based on what. And traditionally, we have looked at what populations are traditionally been oppressed, and that was really the analysis that the court was doing, and saying, well, women, people of color, anyone who has been traditionally oppressed, then that's kind of a suspect, even based on religion, that those are suspect classes. And so we are going to apply a stricter and more careful analysis, and we're going to be more wary of laws that impact these populations and discriminate on the basis of those categories than we would previously. And or if it's discriminating based on, because you can imagine there are laws based on discrimination based on if you're wearing a red scarf or something like that, something that's very random, but it doesn't really affect a particular group that has been historically oppressed. And so we're just seeing a complete earthquake, kind of like a tectonic shift in what the analysis is and what is going to be protected in the future. Some of the effects we're looking at are, what are the unsettled questions of constitutional law that we just don't know how they're going to play out. They haven't been decided by the Supreme Court. And one of the ones that has been talked about a lot is the right to gender affirming medication and care for transgender individuals. And that is something that has not been decided by the Supreme Court. And I think at this point, we can probably, I would say it's safe to assume that we're not going to see any movement in that direction to uphold that kind of a right. So it seems like states are probably going to be able to regulate that as much as they want. We don't know for sure, so that will probably come up to the Supreme Court, but I'm not optimistic in terms of that kind of those rights being recognized. In addition to unsettled questions of constitutional law, we're now Roe v. Wade was a very settled question in most scholars' opinions. It's been on the books for nearly 50 years. And now, but all of a sudden now, so that's reversed. So since we're now seeing the reversal of a decision that was decided nearly 50 years ago, which is pretty settled, we thought, well, now a whole lot of things are not settled, possibly. So the analysis that was performed and by the majority calls into question all of these other rights that were based on the rights under the 14th Amendment to what we call substantive due process. And that is, what is the right to liberty, which is the language in the 14th Amendment, is the right to liberty, life, liberty, there's another one, and equal protection under the laws. So equal protection has generally been anything that's race-based, has been recognized sex-based, but the court did not decide that pregnancy was a sex-based classification, or that this would be an unequal protection since only women could get pregnant. So in that sense, we don't really, we're kind of just in a completely different situation. So if we had a law that said women can't, I don't know, travel, but men can travel, or something like that, then those are clear classifications, and that I think that would be struck down. So I don't think that we're in a space where those kind of like very clear violations of rights are going to be revisited, but anything having to do with reproduction, the court has not recognized that as being discrimination on the basis of sex, which is really the laws that they really look to strike down. So the right to contraception is not listed. That's not something that's based on a classification. Fertility treatments, IVF, those things that can result in complications and need for abortion. Again, this is something that we haven't seen this come before the court, but that is something that I think that the court would probably be reluctant to regulate and to restrict the states from doing whatever they wanted to do. The big one here is right to gay marriage. I would say that this is kind of the one that would be next in line in terms of, if we're going to go down this road of revisiting these issues of settled law. Roe v. Wade was decided far longer ago than Oberfeld, which was the court decision, the Supreme Court decision upholding the right to same-sex marriage. So that decision, even though Justice Kavanaugh has said, well, we're not going to revisit all of these things that are based on this same kind of substantive due process theory, we're not going to revisit all of this. This is really limited to abortion. But one, he can always go back on that. We don't know. And two, Roberts did not join in that. So we don't really know what his views are on this sort of substantive due process law, or theory of the law. So we're really like, if you kind of go down this, the kind of thinking that Alito engaged in the majority opinion, it's really hard to start drawing these lines of saying, okay, well, we're going to, there's no right to abortion, but there is a right to gay marriage. There's no right to abortion, but there is a right to contraception. It's really hard to start drawing those lines. So I think that's kind of where we're headed in terms of the future of constitutional law, and where a lot of these questions are going to be revisited. Okay, so I have a question. What about the right to interracial marriage? It's a very good question. That decision was Loving versus Virginia, and it's possible. So there are two main clauses in the 14th Amendment jurisprudence that are generally analyzed. One is this right to liberty. The problem with right to liberty is this is really vague, right? So what is the right to liberty? But we thought at least it would require a right to bodily autonomy. And that was something that was derived from this language of the right to liberty. That's called like substantive due process, basically. And then there is the right to equal protection under the laws. And that says, well, you can't say that at the very least, a white person is entitled to sit on a jury and a black person is not. That would be a very clear violation of this equal protection. We're not equally protecting those rights. Or that something that was saying, okay, it's a crime if a white person does it, but not if a Asian person does it, something like that. That is like sort of clear fundamental 14th Amendment protections. And I don't think we're going back on those. Interracial marriage, I would be really surprised if we revisited that, but it is possible. And because that Loving versus Virginia decision, that rested both on the right to liberty and the right to marriage, so recognizing that that's fundamental in liberty, and equal protection. So I think the equal protection clause in analysis and jurisprudence is still pretty strong, although that could change in the future. But this idea of liberty and the right to marry whoever you want, I think that is where we are back there, back to kind of where are we with that? Because the right to marriage isn't listed in the Constitution. And so previously it had been found that the right to marriage was a fundamental right inherent in our Constitution and in liberty. But that's not, it's not clear whether that would be a something that was protected. That being said, when you look at kind of like the traditions and history of our nation, marriage has been considered something that is fundamental right in the origins of our country. And I think interracial marriage will probably be more closely tied into the 14th Amendment and equal protection than gay marriage would, because it was something that the 14th Amendment was specifically addressing racial issues. So I would be surprised if we revisited that, but it's possible. Right to IVF, it sounds even if one is only handling one embryo, could the states or federal government say that some individuals don't have the right to pregnancy? I would be surprised if if they said that certain individuals don't have the right to pregnancy. I guess it depends on what that question really is. Is it that just anyone who is not sort of like naturally capable of being pregnant, and that you're not, you have problems with fertility, so you don't have the right to being pregnant? That's possible. But I don't think, if you're saying, okay, well, again, the most basic decisions among most fundamental restrictions would be where kind of on that far end of the line where we think it would be definitely be protected, was like, okay, we're not going to say that white women have the right to IVF but black women don't. That would be like, I would say like pretty far protected. If we ended up revisiting that, it would be like very, I would be just incredibly terrified for our country. But if we're just saying that, if we're saying that, okay, you don't have a right to pregnancy by using IVF, then I think that I would not be surprised at all if the court ruled that and saying you don't have a right to use IVF to get pregnant. But if they were saying, making distinctions between classes of individuals, saying that this person has a right to IVF but this person doesn't, that's where it would be probably more protected. But just the right to IVF in general, I don't think there is anything indicating that this court would recognize that right. Okay, so steps to protect you and your family in light of all of these changes. If you're pregnant or considering getting pregnant, I would really probably reconsider any travel to states with restrictive laws, especially if you have complications in your pregnancy. I think that you're probably going to be, and we're already seeing it, we're already getting reports of um, denial of care and or delays in care because there's more bureaucracy and that has to be gone through in order to provide any kinds of life-saving or health-saving treatments. So that's something I would probably just something to consider. If you're planning IVF, I would reconsider if you're planning on moving to states with restrictive laws. That might be something to think about. Transgender medical care, again, you're kind of considering where you're going to be settling. If you were thinking of moving to Alabama, then that probably maybe wouldn't be a great idea anyway for other reasons. But those are the things you kind of want to be aware of, is that if you're moving where you're living. And so we're just at a very different place, I think, in our country and our history of people making decisions really based on just different rights that they would have in different states. For gay rights, rights to children, marriage, then we're still waiting on that. We don't know what's going to come down, but I would definitely make sure that you have documented your healthcare wishes, your power of attorney, anything like that, just in case, even if again, probably consider those restrictive states, but also if you're traveling there for work or for whatever reason, you just want to make sure that you have those documents in place, so that even if they're not recognizing your marriage, that even in all of those states, they do recognize these documents. So that is something to think about. And I think that we'll probably see more cases coming before the court on these issues, trying to get those laws revisited and those decisions revisited. We don't really know what the court is going to come down with eventually, but a lot of this right now is kind of a waiting game, and just doing what you can to protect yourself, protect your family, and do what you can to support the causes that will allow more protections for everyone. So that's it. I hope that was helpful. And I think we addressed, there's one more question. Thinking of the restrictions in Poland where you cannot access IVF treatment unless you are married. Yeah, that's a really interesting issue. And, I think it's really unsettled. And I wouldn't be surprised to see the court rule that there is no right to IVF treatment if you're not married. And so that, again, it could go either way, but let's just say I wouldn't be surprised if that came down saying, if the court came down saying that there was no right like that, and that states could discriminate based on whether you're married or not. So that's another couple of questions. Headline just came in: while the session that House passed legislation to codify contraception rights, though not likely to pass the Senate. That's unfortunate. If we are already in a restrictive, undecided state and not in a position to relocate, are there any suggested ways to protect ourselves if we are considering pregnancy or IVF? Right now, IVF has not been regulated by those states. So I would say, probably maybe do it now rather than wait, because we're not sure what that is going to entail later on. And then I personally, and this is not really legal, this isn't something that I read about legally, but I would probably just want to know where the embryos were being stored and what plans that clinic would have in the event that it looked like this was going to be regulated and restricted, or some of, again, dystopian situation, that are they prepared for that, and what are their contingency plans in that situation? In terms of pregnancy, in most cases, there are not going to be life-threatening or health-threatening complications, but I would say if you're able to travel to another state, if you are having complications, you might want to do that, but just look at the landscape if there are any complications coming up. I mean, even when you're in a situation as far as, childbirth, those you don't know what's going to happen, and we're still sort of just seeing what the implications are. There have been the doctors associations are pressing states now, the restrictive states, for more guidance on, if you have an ectopic pregnancy, what the situation, what they're able to do in different specific conditions. But of course, not all medical conditions are going to fall into a particular classification. So hopefully we'll be seeing at least some clarification on those different conditions and what's allowed, so that but if you do have an ectopic pregnancy and your doctor is saying, I can't do anything about this until it's inevitably going to be a life threatening situation, an ectopic pregnancy, so but they may be reluctant to do anything about it until it is a life threatening situation. So if you do have a diagnosis like that, I would, if you do have the means, to travel to a state where you can get care for that condition and get it taken care of right away, and not wait so until the doctor is comfortable doing it. So I hope that was helpful. And I wish that this was a happier presentation about the state of our laws in our country. But at least I think it's the best that we can do is be informed. And if there's anything that you have questions about or I can help with, then please reach out.